Are you a business owner? If marriage is on the horizon or if you are already married, have you thought about how to protect your business interests in the event of divorce, however unlikely it may seem? Hi, I'm Simon Dippenaar and I'm a family attorney. Contemplating the end of a marriage when you're just starting out in the married life is distasteful to many and may even feel disloyal. We intend marriage to be lifelong, but of course that isn't always the case. According to the latest data available from Stats SA, divorces increased by 13.1% since 2020. Furthermore, if you're watching this in the Western Cape, I've got news for you. Most divorces happen in the Western Cape relative to other provinces. The majority of divorces were from marriages that lasted between 0 and 9 years, followed by those that lasted between 10 and 14 years. However unromantic it may be, it's worth giving some thought to protecting your business interests if things don't work out for you. You'll not only protect your business interests, you'll protect your mental well-being and dignity too, and that of your spouse. Some of the most acrimonious divorces involve couples with shared business interests. They may own the business together, with one spouse having an equal shareholding but an unequal involvement in the business. The other spouse has built the business based on their expertise. Or the business may belong solely to one spouse, but if the marriage is in community or property, any shareholding in the business is part of the joint estate. On divorce, the business is basically divided in the divorce agreement, which is shared equally between the spouses. The spouse's business interests are part of the joint estate. A marriage out of community or property with accrual allows spouses to maintain separate estates during the marriage. The spouse with the lesser growth in their individual estate is entitled to a share of the greater growth when the marriage is dissolved. A marriage out of community or property without accrual keeps assets completely separate before and during the marriage. Now, each spouse retains ownership of their respective assets. If you marry out of community or property without accrual, your business interests remain yours alone and should not be contested in the divorce agreement. If you're married in community or property, then they are part of the joint estate. If you are married out of community or property with accrual and have a successful business, it is highly likely that your growth may exceed that of your spouse, and so your business interests become part of the calculations. The only way to keep a business separate from the joint estate is to marry out of community or property, either with or without accrual. To do this, you must have an antenuptial contract or ANC in place. If you are already married in community or property, it is possible to draw up a postnuptial contract or a PNC. ANCs and PNCs are legally binding agreements that define the division of assets in the event of divorce. They allow spouses to protect business interests and minimize potential disputes during divorce proceedings by specifying how commercial holdings are treated. For example, a business can be totally excluded in the ANC, or the value of the shareholding can be noted as part of the spouse's commencement value. Another way to contractually protect business interests is through the partnership or shareholder agreements or the company's memorandum of incorporation. These can include provisions that protect the interests of the other owners in the event of a divorce of one owner. But what if you're facing divorce right now and none of these measures is in place? There are still actions you can take. Firstly, ensure your business is accurately valued. A qualified professional such as a forensic accountant can arrive at a fair assessment of the business's worth. This valuation will play a pivotal role in determining the division of assets during the divorce proceedings. Secondly, hopefully your business records are in order. You should have thorough documentation regarding your ownership stake and involvement in the business. This can include shareholder agreements, employment contracts, capital investment records, and any other evidence of your active contribution to the business's success. Clear documentation can support your claim to a fair share of the business. Next, you could consider buyout or settlement options. Depending on how amicable the divorce proceedings are, you may be able to negotiate a settlement or buyout agreement with your spouse that allows you to retain full ownership of the business. This may mean transferring other assets or making financial arrangements to compensate your spouse for their share of the business within the marital estate. Lastly, if negotiations are difficult, it's worth investigating alternative dispute resolution methods such as mediation. A mediator may present options you and your spouse have not considered, which may limit the impact of the divorce on your business and facilitate a mutually acceptable resolution. Now, an experienced attorney can provide guidance tailored to your specific situation and protect your business interests. If you are entering into marriage, I can advise you on matrimonial regimes and antenuptial contracts. I can also help you draft a postnuptial contract or, if necessary, support you through the divorce process. To find out more, give me a call on the number in the signature below.